What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. We are working our way through this Colorado Real Estate Commission position statement series. As you guys know, spring of this year, I guess it was, the Commission approved a whole new rewrite and set of all of the Real Estate Commission position statements. A lot of consolidation, getting rid of some obsolete stuff in there. And they are, I believe, really very good learning and teaching documents. And so we're working our way through a number of these things. I'm not going to do, there's 29 of them, I guess, now. I'm not going to do all 29, but I'm guessing I'm going to land somewhere between 12 and 15 of these videos in this particular series, trying to hit some of the high points for you guys and break them down. The next one I'm going to do is Commission Position Statement 4. And this is something that comes up an awful lot on the legal hotline when it comes to realtors in Colorado calling to ask about, sharing commissions with their buyers or sellers. A lot of confusion about marketing that and kind of how things work. So some good learning points in this that I want to chat a little bit about. So we start off knowing that as a general rule, you cannot share commissions. Now understand, commissions versus referral fees, two different things, and we talked about this in CP3, either CP2 or CP3 earlier in the series that we did here. So reflect back on those if you've got commissions about or questions about paying referral fees. But difference between referral fee and commission. In order to perform any brokerage functions, which is what a commission is paid for, in the state of Colorado, you have to be licensed as a broker. So we know that you can't share commissions with unlicensed people. In some situations, you could pay referral fees. Some limited situations you could. But sharing commissions, you can't with unlicensed people. But there's an exception to that, and that is a principal to the transaction. So you can actually share commissions or split fees with a buyer or seller in the transaction because they're principals. And the logic there is that a principal, an individual who buys or sells real estate on their own behalf, they don't need to have a license because they can represent themselves. I always tell people, licensing in any world, in legal practice, in medical practice, in brokerage practice, whatever it might be, licensing is for you to represent third parties, people other than yourselves. If you want to, perform surgery on yourself or be your own lawyer or, be your own real estate broker, you're free to do that without a license. Most cases, that's probably not a great idea, but, I'll leave that to you. So the point is, because a principal, a buyer or seller, who's actually a party to the transaction, since they can perform brokerage services on their own without a license, they could also actually share or be split commissions as part of that transaction too. And so that's why that exception exists. So the question then is sharing or rebating with sellers. If you're a listing broker and you want to rebate your seller some portion of your commission, that's easy to do. There's not a lot of hair on that deal. You can just put it in your listing agreement. In most cases, it probably just makes sense for a seller where it's going to be money just changing hands on a settlement statement as part of their proceeds. Probably just makes the most sense to reduce your commission if that's what you're trying to accomplish with the seller. But to the extent that for whatever reason that wants to be structured as some credit or some concession to your seller at closing on the settlement statement through the listing agreement, that's fine to do. There's not really going to be any hiccups with that. It just in most cases would just take place through the reduction in the dollar amount or percentage, whatever your negotiated commission is with your seller directly. So very easy to rebate or share commissions with a seller. Gets a little trickier with buyers, and this is where really the questions primarily come up. You are free, again, a buyer is a party to a transaction, you're free to rebate commissions, to share commissions with the buyer. It is not prohibited at all under either RESPA or Colorado license law, but here's the big but. It has to be disclosed to the lender on the settlement statement and approved by the lender and the underwriter, not necessarily just the MLO, but the underwriter, because it's going to be appearing on the settlement statement. It's got to be approved if that buyer is getting financing. If it's a cash deal, there's no lender involved, and you want to rebate or give some concession or commission split to your buyer, that's not going to really be much of a problem. There's nobody to really call that out. in the real world, the reality of it is much like the seller situation. It's just shifting numbers on a settlement statement, and should be reflected in your exclusive right to buy with your buyers what that agreement is and what concession or rebate you're going to be giving them. Nobody's there to object because there's no loan. The lender's not going to look at that and go, wait a second, we don't want buyer walking away from the table with cash in their hands. The problem is, in most of the transactions that most of you guys are probably working on, there is a lender involved. And so the lender needs to be made aware of that agreement. It needs to be as part of the transaction, therefore reflected on the settlement statement, and the lender's got to approve it. Otherwise, if you're doing it outside of closing or something, it's loan fraud. If the lender is not made aware, and your buyer, when they make loan application and when they close a transaction, they're making a representation, an affirmative representation to the lender that any agreements, consideration, any financial agreements, anything else related to the transaction has been disclosed to the lender and is reflected on the settlement statement. Well, if they know that they're going to get some kickback from you outside of closing or after closing, that's perjury. When the buyer is signing that statement, they're committing loan fraud, representing that they've told the lender everything when in fact they haven't, because they do have an agreement with you outside of closing to kick back some money post-closing. And so please avoid participating in any of that loan fraud. All right? Make sure you're getting a very clear agreement with the buyer with regard to whatever terms and specificities, amounts. Make sure that's all reflected in your exclusive right to buy with your buyer so that everybody's clear and it's not this finger pointing as, oh, they said they were going to, credit me X% or X number of dollars at closing. Have all of that memorialized so that there's no pointing fingers. In terms of advertising that, you give concessions or rebates or credits to buyers. Nothing wrong with that, but I will say this. You should be clear in your advertising and marketing that you offer buyers credits or rebates. You should probably have some disclaimer that says, upon approval of buyer lender or per buyer lender approval. Because if you're just saying that and a buyer's relying, hey, there's not going to be any problem, I'm getting a loan, and they're going to rely on the fact that you're going to give them some percentage or dollar amount of your commission at closing or through the settlement statement, there's a really good chance their lender's going to have a problem with that. And you should know that if you're making that offer, and they should be disclosed that, hey, I'm willing to do this, but your lender's going to have to approve. To the extent that they don't approve, then I can't do this, unfortunately. And so make sure that you're disclaiming as part of your advertising very clearly to a prospective client that you will offer that credit or concession at closing back to the buyer upon approval or disclosure and approval of buyer's lender. And then the last thing that Commission Position Statement 4 talks about is gifts. You're free without any agreement to provide whatever gift post-closing to your client you want to. But remember, the difference between a gift, which is gratuitous or which is just you being a nice person as a thank you, it can be gratuitous. It can be, you can give them a car if you want to. You can give them $10,000 if you want to. That's an excessive gift as long as it is not a condition of contract. In other words, that wasn't part of an agreement that you had with the buyer. If they work with you and close the transaction to you, they're going to be receiving this $10,000. That's not a gift. That's an agreement. That's a contract. That's an expectation. A gift is, hey, that transaction was really great. It was smooth. Here's my gift to you at closing. That's not a problem. There's nothing to disclose there because in that case, the buyer, when they sign this agreement with their loan payment or paperwork saying that there aren't any other agreements, they can do that truly saying there aren't any other agreements because, in fact, you have no obligation to give them a gift. It's a gift. So understand the distinction between the two of those things and don't let those lines blur out. Anyhow, I hope that helps a little bit with your questions on this issue because it is a very common topic that we get on the legal hotline. If you have more questions about this or anything else, we always love to hear from you there. We will see you again on the next edition of Legal Bites.